Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
Today on the Contract Teardown, attorney Jim Lowry talks about Cook County's standard residential real estate contract. So let's tear it down. Jim, thank you for joining the Contract Teardown Show. How are you today?
I'm doing well. Thanks, Mike.
We are going to look at a document. Let me share it with the folks at home. It is this multi-board residential real estate contract 7.0 in Chicago town. Tell me about this document, Jim. What is it? When are we going to see this kind of thing?
Well, you're going to see it quite often here in the Chicagoland area. The Illinois Supreme Court back in 1966, in a case versus called Quinlan and Tyson, said that real estate brokers can't draft contracts in Illinois. So they have these pre-printed forms here, and brokers are allowed to fill them out, but they can only be changed or edited by attorneys.
Oh, awesome. And we're going to talk about attorney involvement. But before we do that, let's talk about you, Jim. What's your background? What brings you to documents like this? Tell us about your practice.
Yeah, so I am in the northwest suburbs of Chicago, in Des Plaines, Illinois, where I do a lot of real estate transactions, commercial litigation, estate planning, etc.
Perfect. So you got the background we need for this conversation. So what we're going to do, Jim, now is, as we do dig into this thing, to get started, though, I wanted to ask you a little bit about these standard forms. You mentioned that the Supreme Court said you can't do, brokers can't write, so let's create a standard form. I've been in states where standard forms became a massive fight, obviously, but real estate seems to generally be okay with these forms existing. Tell us about the use of forms in Illinois and how people have reacted to it.
Well, normally, from a normal consumer standpoint, they really don't notice the difference. However, in the attorney world, this is a multi-board real estate contract that's been approved by both attorneys and the brokers, a lot of the managing brokers and big players in the Chicagoland area. So they get together every few years and figure out the trends and what's going on here in the Chicagoland area and try to meet the concerns on it, that they see on a daily basis.
Got it. Okay, so we've got the standard form, residential, targeted to consumers. Presumably the commercial side would be more complex than this, but we're trying to standardize for consumers. And what we're going to do is jump down to some of the sections that are common in your area and a couple of the adjustments that they've had to make because they're using a standard form. So let's start with number 9. We're jumping down to prorations. We were talking in preparation for this. There's some tax implications. Talk to us about Section 9, what it's trying to do, and do you like the way it's drafted?
I like it in some respects. So in Illinois here, they have the taxes are paid in arrears. So you're in 2022, you're actually paying the taxes are assessed. They're paid in arrears. So you pay your 2021 taxes in 2022, and they're paid twice a year here in Cook County, which is the largest county in Illinois, which most of the real estate transactions occur here.
Right, and so this section is talking about those property taxes. Is that right? And so
that's correct.
What's the solution here? How are they solving this issue of the weird situation with the weird years?
Well, presumably your taxes are always going to go up because Uncle Sam and his progeny like their money. So we can't get a handle. Without knowing the full tax year. Say we're selling a property here in March of 2022, you're not going to know the taxes this year. So the closest estimate you can get is you're trying to hit a moving target. So you do a proration. So typically here it's 105 to 110% of last year's ascertainable tax bill.
Got it. And it's saying in here, it's got in the language a bit of what's included, what's not included. It shows that accumulated reserves of a HOA are not a proratable item, but it talks about the tax year of the closing, utilities and water, pre-purchase fuel. So it looks like what they're trying to do is, because like you said, it's paid in arrears, just make it so the person who's moving into the house is not responsible for time that they weren't in the house, which makes sense. Well, let's talk about 10. This section is interesting. It talks about the attorney review. Again, thinking of the context of this is a standard document that was approved by the Supreme Court, by lawyers, by brokers. Talk to me about Section 10 and what the relationship is with the lawyers for the two sides in this kind of standard document.
So typically what happens after a contract is signed and by both parties, we have offer acceptance. you have 5 days to write an attorney review period, or during that, you have 5 days, 5 business days. So essentially a full week to write a review letter making changes to the contract as it is. Typically we include, which we'll get to later, you'll include your your inspection issues as well. But you can either approve the contract as written. Nobody does that because we're lawyers, right? And we need to make our money. Unless it's like an as-is deal in a property that is in a less desirable area that a prospective buyer is going to either raise the property or they're going to make the improvements, bring it up to code, and make money, and then flip the property or rent it out.
What an interesting thing. You see, especially in a town like Chicago, the difference between the have neighborhoods and the have not neighborhoods is so vast. And here's a systemic way that you'll see different outcomes, presumably for the different neighborhoods. How common is it to have a lawyer involved in those kinds of transactions, but they sign off on, we're not going to do much in the way of review? What typically do you see in transactions of different sizes in terms of attorney involvement in Chicago?
I would say 95% of all deals have attorneys, maybe even closer to 100% have attorneys representing both sides. Just mainly because here the seller's attorney will typically take on the role of being a title agent, and they'll actually aid the title company in making sure title is clear. If there's encumbrances or liens on the property, they will clear that up. And those could be anything from building violations to maybe something that got recorded incorrectly with the recorder of deeds.
Got it. So it sounds like maybe the difference between the high dollar transactions and the lower dollar transactions is not whether an attorney's there, but just how much they're allowed to, push back, if they've got the money around for a lawyer to push back. Talk about then the process that's in Section 10 here. Is it realistic? Does it give the attorney the room that they need to push back and make changes? Specifically, we were talking a bit about the timelines. What do you think about the way that structures this sort of pushback period?
Well, for us, when you coincide this with the inspection period, it can be difficult if you can't get an inspector out to the property. Then you're constantly going back and forth, writing extension letters, and especially as a buyer's attorney. Hopefully, the seller's attorney is going to be gracious enough to give you that the benefit there, and their clients are going to agree to that. But sometimes in a multiple offer situation, they're not going to be. So I would say when this contract was drafted, 5 days made a lot of sense. But with the increased volume in sales now, it can be a little bit more difficult to get an inspector out there. So you are starting to see some buyers' attorneys push back and say, hey, can we have 7 or 8 days? And it's not atypical to see a buyer's attorney right off the bat shoot an email over to the seller's attorney saying, hey, I need X amount of days because I can't get an inspector out there until next Friday.
Yeah, it's almost like creating a speedy trial requirement. I remember being in a city, it was in Houston, when I was in Houston, and they had a speedy trial kind of requirement, especially for certain kinds of proceedings, and it was so rare that the court could take something within the 2 weeks that was required for the certain kind of pleading. So the court would just automatically grant extensions. And so something that was required to be done within 2 weeks was actually 4 and 5 weeks out. And it even says in here in this document, if notice of disapproval or proposed modifications is not served within the time specified herein, the provisions of this paragraph shall be deemed waived, which is a big difference, and it'll be in full effect. So you want to make sure that you get that timeline. Well, then it talks about, we talked a bit about 11, the waiver of professional inspections, and then also 12, these timelines of the inspections. Talk about the inspection period, and to your point before, how it applies to an attorney's relationship with the document. How does it change how an attorney will deal with this process?
Well, attorney's going to have, their main thing is coordinating the timeline, making sure everything flows through. And so you're dealing with two different aspects here. One, you're dealing with the inspection, which is, we'll get to a little bit later, the ins and outs of that. But you're also coordinating the drafting of the language. What do you want to include or disinclude take out of the contract? For instance, paragraph 10D, most attorneys here, we take it out. We don't like that language because it's very confusing when you compare it to 10C. 10D requires you to reference that paragraph, and I've seen other attorneys that don't do a lot of real estate law. They forget to include a specific reference to 10D, and then 10C takes over, and now you're in a situation where it's deemed a counter offer, which you may not want. So now you're in an counter offer situation, and we all know from law school that a counter offer is deemed as a new offer.
Yeah, that is clumsy. I'm looking at D. Offer proposal specifically referring to the subcontract D, which shall not be considered a counteroffer. Yeah, so it sounds like, if you decide not to do that to the clause later, it's deemed as waived. 12 actually goes into quite a few steps. It looks like, for how to deal with the inspection. Talk to us about how this structures the inspection in terms of the timeline and the response, and who's proposing what, and after an inspection, and how that changes the contract.
Well, the inspection and the attorney review period they both run together. But like I was saying earlier, it can be very difficult to get an inspector out there, and even if you haven't out to the property that's being purchased. However, it still can take a day or two for them to write the report based on how busy they are. So you get that report back, then you have to speak to your client, go through it, and as a buyer, and say, hey, what's a big deal here? And the problem us attorneys have is that we're not going out to the property. We're not real estate agents. So sometimes these photos don't do justice as far as, is there a heating duct that's disconnected? Does it look like mold in the attic? Is there a shingle off the roof? Something like that.
Yeah, and to your point, before we move on to some big picture questions, anything else to add about this inspection period and how it changes the contract?
Yeah, the one thing about this is that this is only related to big issues. So it's your heating, your cooling, your roof, structural issues, foundational issues, things like that. But the minor cosmetic issues aren't deemed to be, material to the contract, which is something worth noting. Now that can be difficult in a situation where you're having new development. Like I've done some condo development, then you have somebody coming in and saying, well, that's not the model washer and dryer I ordered, or something like that. So that can be a little bit difficult.
Yeah, especially since the reason you're buying the new property is so you don't have to deal with all the accepting the changes. Well, moving on from 12, and thinking of the big picture, it sounds like this document is old. It's been revised over and over again. And when I'm thinking about this sort of standardization, there's the question of, does it work? Does it do what it's supposed to do? Maybe in an all-consumer situation, you know what I mean? This kind of standardized document works. But when there are lawyers on both sides, as a practical matter, it almost sounds like this is a third client. As the two lawyers, you're looking at what your clients both want, but then also what just this document wants. Talk to me about the efforts of standardization and whether you think documents like this really help in terms of restricting lawyer hours and moving the process along faster.
I think the theory of a standardized document like this is a good one. Also, given that court case I spoke about earlier, the Tyson and Quinlan case, the brokers aren't equipped to generally deal with this. And sometimes they don't even fill out these completely. So then us as lawyers have to go ahead and fill in the blanks and rewrite the contract anyway, make amendments through our attorney review letters. So I think the theory behind it is good. However, with evolving times, these need to be revised quickly, or maybe more frequently. And sometimes they try to come up with every single scenario that's possible. And I think some of the drafters often go into too much detail.
Yeah.
So every time a new one of these, go ahead.
Yeah, it feels like a trade-off, right? It feels like you can do what the lawyers want you to do and imagine all the parade of horribles, but now you're at the point where we're trying to cover every situation. It's not contextually appropriate, and we've just added a bunch of time, right? Which is what we were trying to kill in the first place. It's an interesting struggle with these standardized documents. Well, Jim, I appreciate you bringing this one to us. For people who want to learn more about your practice and what you do in the Chicagoland area, what's the best way to reach out to you?
At email at jlowry, JLOWRY, at jlowrylegal.com, or 312-445-9450.
Perfect. We'll include all that information as well as a link to this document over at lawinsider.com/resources and in the comments below on the video. We will also ask if you want to be on the show. If you want to jump on and tear down a document like this one, just email us. We are at community@lawinsider.com. We will see you all next time. Jim, thanks again for joining us.
Thank you, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.